Welcome to Week 9. This week the focus of our unit is on some issues you probably didn't plan on being involved in when you decided to be a teacher of students with special needs. But they come with the territory, so to speak. For every right, there is a corresponding duty, and for every violation of the duty, there is a remedy. IDEA provides for remedies for violations of any provisions related to any of the 6 principles. The remedies forestall future violations, compensate for past violations, and include the start-over remedy. IDEA provides for federal monitoring of SEAs and of SEA monitoring of local education agencies, or LEAs. The monitoring is based on information that the state education agencies, or SEAs, must provide to the Office of Special Education Programs, and that the LEAs must provide to the state education agency. To facilitate monitoring, SEAs must file performance plans with the Office of Special Education Programs, or OSEP. If OSEP disapproves of the plan, the SEA is advised of the following: technical assistance, conditions for the use of SEA funds to assist LEAs to comply with IDEA, and OSEP activities for states that are in need of assistance, intervention, or substantial intervention. As a general rule, courts have been reluctant to assess money damages against an LEA or SEA that violates IDEA, but they do provide for compensatory education, extended school year, and tuition reimbursement remedies. IDEA provides that students and parents whose IDEA rights allegedly have been violated may proceed under IDEA itself through a mandatory resolution session, mediation, due process hearing, or other such due process kinds of things and appeals. Or they can proceed under the Americans with Disabilities Act, Section 504, and the Civil Rights Act, Section 1983. But as the courts interpret IDEA, those laws only if the violation is over and above any IDEA violation. Courts have been reluctant to award money damages when an IDEA complaint is coupled with an ADA 504 or Civil Rights Act complaint. One reason for the court's reluctance is that IDEA itself provides for a comprehensive scheme of remedies that does not explicitly include damages. Another is that state sovereign immunity prevents a student from suing a state, but interestingly not from suing a local education agency. The third reason is that the Civil Rights Act provides that the person who violates the student's rights must act under color of law, a doctrine that the courts narrowly interpret. IDEA provides that a prevailing party may recover attorney's fees, and this provision can benefit the student and parents as well as the state education agency or local education agency. IDEA and the courts place limitations on the amount of the fees, require the parties, the students, parents, LEA, and SEA, to comply strictly with various procedural requirements, generally bar recovery for attorney services and in IEP meetings, mediation, or mandatory resolution session, and interpret prevailing to mean that the legal action has caused the defendant to make substantial changes, not minor ones, in practice related to the student, or a policy related to the student and others as well. IDEA does not allow recovery of the fees of people who are not attorneys but who advise about IDEA violations, and the courts have been divided on whether to allow for recovery of the fees of expert witnesses. Like I said, not something you expected to deal with, but critical nonetheless. This unit is important, so read carefully.